sent it out to me. $700,000 check just winds up in my office. How do you lose track of $700,000? So with the trust, you're using that pour-over will. That's providing protection on that privacy. Okay, just emphasizing that point again. If you have a client and they want to avoid probate, do the trust. If they don't care, have it line up with the will. Many years ago, this was a financial advisor who asked me about this because he just wanted to make sure his client's kid was taken care of. He had been trying to get this husband and wife over to me to do their planning for several years, and we'll get to it. They, in the meantime, had their daughter listed as the pay-on-death beneficiary for their investment account, which, this is probably more than 15 years ago. At that time, it was $650,000. She was 17 years and 9 months old when the parents died in a car accident. She gets all that money as soon as she turns 18, drops out of high school, marries an unemployed 25-year-old man, buys a big house that really she's not going to be able to afford to keep up. And then she says, well, I have $115,000 in the bank. I'm never gonna have to work a day in my life. All right, there's wasting an inheritance that ruined her life. So even if they said, all right, we're gonna do a will and have it pay on death to the estate, and there were age limits in a trustee, even though it was a testamentary trust, that would have been better than what actually happened. All right, so how do attorneys get probate work? And I see this all the time, and I thought about it. Why would they have generally a pour-over will, but they would still have distributions of the personal property done through the will? Does anybody have any guesses on why they would do that? Well, money, why? How?
They get paid for through probate.
Yeah, the personal property goes through probate, but is that really that big of a deal?
Yeah.
It's because every beneficiary has to be notified at different points along the way, and they have to put all of that paperwork together. They have to have the beneficiary sign off on all this stuff, and so it's just creating more work for the attorneys to do, where the right way to do a pour-over will isn't just the residue goes to the trust, it's everything goes to the trust. And if you're doing the trust, we have the assignment that automatically moves that stuff in right up front, so it's not even part of probate anymore. Yes, Nora?
You know, we have a local lawyer that is what he does with the pour-over. And I looked at that and I'm like, why would you do that? And it just didn't occur to me. But yeah, we have a local lawyer who does that.
Yep, it's part of the paperwork for probate. It's you got to notify the beneficiaries, get their consents, they got to sign the releases on when they get their stuff. That's why they do it. All right, now probate fees. I've heard attorneys that do a lot of probate say, oh, probate fees in our state aren't that high. They're usually not really answering the question, and they're talking about the court costs. So we're going to get to where on these initial filings and inventories these assets are, but North Carolina bases their fee, in addition to the minimum, on how much in these Section 1 assets. Checking, savings, stock accounts that aren't pay on death, that are part of the estate. Doesn't include real estate, doesn't include life insurance, doesn't include IRAs and things like that. But it does handle personal possessions. So just another story, I had some clients that did a trust and they tried to get mom. They wanted mom to do a trust. Mom was an antique dealer. She was a sole proprietor, and she had a lot of good expensive stuff in her house. When she died, she immediately maxed out the probate fees of $6,000 for North Carolina, just based on all of the antique stuff that she had in her sole proprietor inventory and in her house, just like that. That would have more than covered the cost of a trust and having it done just based on those fees that went to the court.
If you think it's important for educational videos like this to get out there, then please help us out by subscribing to the channel.
All right, so the first step, what is in probate? This is where you're reviewing all of the assets. We have a form and you're gonna have access to it. On the last slide, there's a little QR code you can get to download it. I'm gonna keep that up there until the end of next Tuesday. So you can actually download what we have and use in my office for probate. So it's the form we use. It's always imperfect until you actually get the right information verified, which the court's going to end up needing. Now, financial institutions, until you get those letters testamentary, they're not going to give you anything. So I'm going to just give you another story, and again, forgive me, I tell this all the time if you've heard it before. It's the story of Harry, Charlie, and Patricia. Harry was a client of mine. Him and his wife, they did their planning. We got a revocable trust in place. It was funded. But then Harry calls me up one day and he says, Jeff, my best friend just died. I work with him. I tried to get him to come over to you, but he's not married, no kids, so he didn't see a lot of urgency in it. But now they're trying to ask me at work, because they know we're friends, where's his 401k go? What do we do with his last paycheck? What do we do with all this stuff? And then he told me how he died. They were out playing golf. They get to the 19th hole, they're gonna go have a couple of drinks, have lunch, and Harry's talking to Charlie, he's like, I don't feel well. You know, I'm just gonna go home and I'm gonna lie down. I don't feel well. 10 minutes later, one of the servers comes rushing back in and grabs Harry, dragging him out into the parking lot. And there, behind the wheel of the car, in gear, foot jammed down on the brakes. Charlie, dead of a heart attack. Wow. 57 years old. Wow. So, okay, well, no parents, no kids, no spouse. He said, yeah, both of his parents are deceased. And I think their estates are still in probate. It's been a couple of years. And his siblings, oh yeah, he's got one sister, Patricia. All right, under North Carolina law, Patricia's the heir. Call Patricia. She takes a bus down to North Carolina from New Jersey. I'm explaining the process. I don't want to do this. I can't do this. I'm not capable of doing it. And after talking to her for a little while, I'm like, yes, this isn't something that she's going to be able to handle. She turns to Harry. Harry, will you do this? Okay, I'll do it. So we get the paperwork together, send it in. Harry is doing it. She assigned that I don't want to do it. I want Harry to do it. Great. Week and a half later, I get a frantic phone call. Harry is one of the few clients who actually had my cell phone number, and he called me on a Sunday. And he's like, Jeff, I'm over at Charlie's apartment. There's police and fire department here. And it turned out Patricia was staying at her brother's place, was smoking a cigarette on the couch.
Oh no.
Went to go lie down and that cigarette wasn't completely out. Couch caught on fire. Everything was sealed up, so the fire put itself out, but it also killed Patricia.
Wow.
And of course, New Jersey, suddenly all the cousins are coming out of the woodwork. Oh, Charlie had this, I want this. Charlie had this and I want this, and I want all of this. Hold on. None of you are Charlie's heirs. You're Patricia's heirs. Meanwhile, we still have the two parents' estates open. Charlie is a half beneficiary on each of their estates.
Right.
We can't close this estate until the parents' estates pay into Charlie's estate. And then Charlie's estate has to pay over to Patricia's estate. So go back to New Jersey, where Patricia was a resident, and start a probate there. This was such a huge mess, and I hate probate. I really don't like it. At the point that the attorney from New Jersey started using four-letter words, thinking he was getting a nice Southern gentleman down in Raleigh, North Carolina, and I responded with my Rhode Island Italian upbringing, and the accent suddenly started coming back, and you're not going to talk to me like that, all right? Pass it off to someone else. A couple of months later, this attorney's like, yeah, when the cousin came to collect the personal property, Charlie had actually stored everything in his garage to save on some fees. Cousin showed up 4 hours early. Harry was outside with a BB gun shooting at him because he was getting on his property 4 hours early, and the sheriff had to get called. All of this could have been avoided if we had a revocable living trust set up. Anywhere along that way, it would have saved so much time and aggravation. All right, so what's titled in the deceased person's name ends up in probate. The assets not going through some other probate estate, like in this case, that had to happen. Now let's talk a little bit about probate light options. This is where you can have a small estate. All right, it's a little bit more of an expedited process. It's as long as, I think it was not any real estate as part of the estate. And in North Carolina, it's less than $20,000 in accounts, vehicles, and personal property. What's your state's number?
50.
50 in Tennessee.
50 in Tennessee,
50.
50 in Virginia. Anybody higher?
183,000.
Wow.
183 in California.
Real estate has to be under 50.
125 in Louisiana.
125 in Louisiana. You said the real estate has to be under 50?
When that's gonna happen in
Okay,
California?
yeah, exactly.
That ain't gonna happen.
Unless they're renting, there's, yeah. So those numbers can be pretty small, relatively speaking, to use this expedited process. And generally speaking, it's like, okay, you can list all of those assets, exactly what the fair market value is, and then the administrator can just go collect the assets and fill out an affidavit that it went to the beneficiaries, they signed off. We can avoid the long process. There's also a spousal allowance in North Carolina. It's $60,000. That kind of comes right off the top. So if there's a surviving spouse, by law, they get that first $60,000 free of any creditor claims at all. And so the spouse can just go and collect that stuff. And the bank will fill out, here's what the exact amount is. And so even if it's like, well, I collected $35,000, I think that's it, that still remains open in case something else pops up. So much, much easier if it's just a surviving spouse. I also just want to talk a little bit, and it's going to come later, but I might as well handle it now. Real estate in North Carolina isn't technically like a probate light issue unless it was actually willed to the estate. It's just somebody had a house and they died, even if it wasn't a joint owner. If there was a will, as soon as the will is filed, title transfers to the beneficiaries. If there is no will, title automatically transfers to the next of kin. Now, the reason they do that is they don't want property sitting there for 10, 14, 18 months without somebody being responsible for the taxes, without having to deal with the utility bills and other stuff like that piling up because nobody's paying it.
Right.
It's automatically vested. Doesn't mean the court isn't going to end up having to get involved in some fashion when the beneficiaries are trying to sell that asset because the mortgage company wants the probate court involved for some reason, but that's another aside. Right, so here is the overview of the general process. Now, I mean, really, if you're looking at the actual probate stuff, it starts with the application, but I put the first phase is us gathering as much information as possible about the estate from family members, for whomever's going to be the executor, from whoever's going to be the administrator if there isn't a will, gathering as much information as possible. And like I said, there's a form you're gonna have access to that you can keep adding stuff. It's kind of like more like a folder system, and you can keep putting the proof in there. Yes, David.
Yes, I assume you come across this, I come across it often. I want to start probate, okay, and you gather information. Well, it's depressing to go into mom and dad's house. We haven't looked. Sir, man, we really need you to gather information because there's documents that might be in there, like a will or payable on death. And it's an ongoing battle. And then they say they've done it all, and you started, oh, look what I found. Well, where'd you find it? In dad's bedroom. Didn't you look before? I was depressed.
Yeah. I do get that they don't have all the information. And yeah, maybe they're coming up with their own excuses to not go and look, because it can be tough. And maybe you see it this way. It's especially tough if it was mom or dad and it was the home they grew up in.
Yeah.
That actually compounds it and makes it worse. Yeah, Jerry.
Tacking on to Dave's comment, the one thing that we will learn from experience, when the client takes a will, they should tell the kids where they put it.
Yeah.
I just had this very close friends. They did mom and dad's wills back in 2008, 2009. Mom just passed away this past April. I called my friend Shelley, do you have the original will? Yes, I do. I go down to the probate court with her copy. I have another will in my file, okay? Go down to the probate court, copy. I want to open up an intestate because she's the sole child.
Yeah.
The chief probate clerk says, well, since there's a credit shelter trust built in, because they did it when they were still in state tax in New Jersey, so I just literally had to bring an action to get the copy of the will admitted to probate. So instead of spending $300 and an hour or two of my time, I now have to spend 20 hours drafting all these papers.
Yeah.
So just tacking on to Dave's thing, if you can employ your clients, telling them to do things like getting a horse to water, can't make them drink.
Right.
Let the kids know where the original is to avoid these problems.
Right. That's good record keeping advice to give to the clients. Now, I think I mentioned yesterday, we always execute 2 sets of originals and we keep a second set in my office and we scan it. So there's at least copies that are out there. Yes.
To speak on the side of your client or the person going through that, my parents died 13 days apart. So when you have to do that, and it was before I knew Nora, this would be 20 years ago, I knew that they had things set up, I knew where things were. But when you walk back into that house, when one is gone and 12 days later you're taking the other one out and you're coming back and they're not there, you are overwhelmed, you are not thinking, you know what you have to do, but you can't put your foot across that threshold. And so when you think about it that way, and if you've never gone through it, and maybe even some of us in here haven't even lost a parent yet, and what we tell our clients is until you walk those waters, you don't know how hard that is for them.
Yeah.
And then the disrespect you show when you start going through things, even when you know they're there, and and then you see on the letter of something he wrote, hold, on hold. Hold for what?
Yeah.
So when you think about those things, so you're both sides of that story, but if it's that close, in my case, one of us, it was only 2 of us, my sister got stymied with the emotions. I'm like, we have to do this, but the probate clerk, because we took it through probate, because we thought this was what we had to do, it was a 6-week hold before I could even get to probate court. So that gave me time to wrap your head around when you're calling a funeral director that you've known your entire life within 13 days and say, I gotta do it again. All you're thinking about is what's in front of me today.
Yeah. That's a very good point. This is something your clients would be going through. This also ends up being a good lesson and a story for us to try to stay up with our clients, at least on an annual basis.
Correct.
So that we know what the assets are. We can go through, where do you keep the original, or like my office, duplicate originals. Next time you update that plan, if you didn't do duplicate originals,
Get it?
do it. Get that second set and hang on to it. We've actually had a couple of cases where we had those duplicate originals. Kids called up, couldn't find the original, or the clients wanted to go with the local attorney. They want the original. All right. Don't hear from them for a couple of years. Well, we never went through with that attorney, and we can't find the original that they had. We want your original. And they sign it out. I make them sign out that second original. A couple of years later, well, Mom died. Where's the original will? You signed it out, but we keep that paperwork to cover us. But just as a matter of course, keeping a second original in your files means if the family ever comes back to you, you're gonna have it. But to Jerry's point earlier, I'm not keeping the only original.
Right.
That's just
Yeah.
their marketing thing. Okay. Right, so the next step after that is the application. And that's where, okay, you're gonna take your best guess, send in the information, because you're not gonna be able to get exact numbers. This is getting someone approved. The inventory is when the court wants to know the exact numbers, because once you're approved, or someone's approved as the executor or the administrator, now they have the authority to get those exact numbers. And I don't know if it's different in other states. I know North Carolina, they want the exact date of death value. And so those numbers have to be lined up, and so you can get that information now. The accounting is when, all right, we had those starter numbers from the inventory, all that's verified, what money came into the estate, interest, found other assets, whatnot. What money went out of the estate to pay bills and whatnot, okay, invoices, all that stuff, cancel checks. And then the money going out to the beneficiaries, and that better equals zero once it's all distributed out. And then, all right, there's the trust settlement. If the beneficiary is the revocable trust, the money went in, and now the trust handles it. So that estate administration report that I talked about, actually, I'm going to talk about one more story. Ancillary probate in California. Who's here? You're California, anyone else? Okay. Usually if it's North Carolina and there's some kind of ancillary probate in North Carolina, it's okay, we just give them whatever the information is because it's the executor, they send their papers in. A couple of years ago I discovered this isn't the case in California. In California, if there's an asset out in California over a certain amount, which we couldn't find out what the exact amount was, because no, you got to go and get an attorney in California to file for an ancillary probate in California. So I had a client who passed on, and he passed on in North Carolina. He was living with his son. It was a terrible diagnosis. Gonna only live 6 months, lived 3.5 years. Okay, good, he had extra time with his family. Son was a wreck. So we got him qualified as the administrator. Him and his brother, they were the only beneficiaries. He wouldn't do anything for about 7-8 months. And then finally he's like, I can't do this. He tells my assistant at the time, basically I'm a functioning alcoholic. I just can't do this. Can you do this? And so they get me set up as the administrator. And my assistant starts trying to track down whatever the assets are, calls California where his girlfriend was from 4 years ago. Well, yeah, I know there's an account because I know we had 2 accounts he got statements. One of them was joint with me. I already have that $60,000 or whatever. But I know there was another account. How much? I don't know. Here's the bank. Bank wouldn't tell us either. Got the attorney, got it set up. We went to court, handled all that stuff, got possession of the assets, sent it out to me. $700,000 check just winds up in my office. How do you lose track of $700,000? I mean, maybe I'm just not rich enough, but that's something I'd have a record of. There were no records for that. It's 5% in California for an attorney handling a case. They got $35,000. Good news on my end, personal representative, they get 5% too. I got paid more on that one asset than all of the rest of the probate that I did. But it was discovering those assets and having to find out. If my assistant hadn't been more diligent, that would have probably popped up about a year ago as unclaimed money. So, all right. Staying organized helps so much. That's exactly what this administration report is about. And keeping track of it along the way. I don't know about you, I'm not necessarily the most organized person with my files. I am thanking God it's so easy to scan stuff and just drop it into the files, and I'll just date it and so I can see what it is now. But the paper files I'm terrible with. This was the only way that I could stay organized, is using this administration report and putting all of the supporting documentation behind the correct tab for each asset. So if it helps you, please go ahead and use it if you ever have to do probate. Now the application, this is your best guess in order to get qualified, and they're going to need, I know in North Carolina, it's the death certificate, the original of the will, and there's several court-specific forms. And that includes, all right, there's got to be an estate's action cover sheet. All of the beneficiary personal information has to be put into the actual application. So name, age, and address for each beneficiary, the personal representative's personal information, that best guess, and this is an important thing to also put in there, the wrongful death claim. I don't know if you've got this on any of your specific state forms, but if there is even any possibility that there might be a wrongful death lawsuit, you check the box yes. Because if it pops up later and the administrator, who is the person representing the person who died, they checked no, that becomes a big issue in the actual lawsuit. The other thing with North Carolina, it might be different in your state. Those wrongful death proceeds do not go to the estate, they go to the next of kin. So even if they hadn't talked to their family in 20 years, they're the ones bringing the lawsuit, they're getting the money, not their unmarried partner that they've been with for 20 years. There's also an oath of office. You do have to swear or affirm under oath that you're going to be a good executor and not steal money. We have an estate tax certification form. North Carolina has not had an estate tax for at least a dozen years, but you have to certify that there aren't any federal estate taxes. You have to fill out an order for the clerk to just sign. Technically they'll do it, but then they get a little ticked off that they're the ones having to do the form, so you fill out the form for them. And then there's the filing fee and a bond waiver. Okay, I know most of the wills that I've seen waived bond if that personal representative is a family member, it's a friend, it's so-and-so. They don't have to get a bond. But if it doesn't list it in the will, and I've seen enough bad wills, that yeah, you have to either go and get a bond, or you got to get all the beneficiaries to sign off that they're okay without a bond. Excuse me. Now, what's the end result of all that paperwork? You get your letters testamentary, if it's a will, or your letters of administration, if there isn't one when you're talking about probate. So this is probably a good time to tell this, because I get this call all the time, or more specifically, Jennifer and Charlene get this call all the time. Yeah, my dad died, I went to the bank, and they won't give me access to his account. They said I need this thing called letters testamentary. Can you type that up? No, that means probate. And that's when I have to break the news to them that you can't just take the will down to the bank and say, see, I'm the executor, give me the money. No, it's the whole court process. So now there's a phase between the inventory and getting those letters testamentary, and this is where you're going to start gathering information. This is where you're going to start lining things up. You need a tax ID number for the estate, and then you need that to actually open up the estate bank account. Just a best practice. Anything that can just go into the estate account, so it's all going into one place, fine, liquidate it and put it in there. If it's something like, okay, it's family stock, it's stock for a family business, all right, obviously you're not going to liquidate that, but that's the exception. By and large, whatever happens, sell it, put it into the estate account. And then you need the exact date of death values. Now, this drives my clients crazy because I have to explain it to them, often more than once if they're the ones running around to get the information. Don't just get a copy of the bank statement from the last month. They died on the 15th. See here on the 12th, it said it was this amount. And then the next entry is the 17th. So obviously we just averaged the two. Oh no, the court will not take that. They need a separate letter from the bank signed by someone who works there on the bank letterhead stating, here was the exact value on this particular date. Again, just much more formal process, and just one more reason why I try to get my clients to do revocable living trust so they don't need to do all of that stuff. So that's the exact date of death. And then you've got your different assets that are going to need some kind of valuation. So bank accounts, real estate, again, in North Carolina, if it's willed to the estate, there's no specific heirs that they have to put specifically they want it to be part of their estate rather than here's who the beneficiaries are with an automatic transfer. You then have to value the real estate. Stocks, bonds, mutual funds, vehicles, artwork, personal possessions. Now just in general, for North Carolina, it might be the same in your state. Unless you're talking about like that antique furniture or artwork and stuff like that, they're generally gonna just take a round figure that you put in there, and it's not gonna need some kind of formal inventory unless someone objects. Now, Jerry, I gave you that story of the pocket knife that was appraised for $5, sold in an estate sale for $3. That's someone contesting things and making trouble. All right, unless you have that, they'll take the round number. And the other good thing when it comes to vehicles, North Carolina will just take a printout of Kelley Blue Book as long as you've gone through the website, you've put all the exact features that are in there. They'll take that valuation as what the vehicle's like, what it's worth. Now, I also kind of caution you, because a lot of times in probate, I have family members that want the car. Okay, use the exact valuation from Kelley Blue Book as part of their share, or have them buy it for exactly that. Because the other beneficiaries, if it was a $15,251.86 according to Kelley Blue Book, you had the nerve to sell it to them for $10,000, they're going to create trouble over that $5,200 and plus difference. So do it for exactly what that value is. It also, this is something that I've seen, if you've got a vehicle that has to go through probate and it's for a pour-over will that goes over to the revocable trust, retitling it from the individual name into the name of the trust is what you should be doing according to the will. And then you have to retitle again. That's 2 retitlings to the beneficiary. Why not distribute the money if they're a beneficiary of the trust? Distribute them some of their money so they can buy it for exactly what Kelly Blue Book does in probate, only 1 retitling. So it's a way around that. IRAs, 401ks, retirement accounts, pay on debt. That's pretty easy to get the date of death valuation. And then, all right, life insurance, if it goes to the estate, you need to have all of those exact values ready